So it's now directing you to YouTube. And then at this point, I wait until the YouTube screen pops up with this page. X out of this. And so this is the difference between the challenge we got email address that we used to use and the one that you're connected to now. So it's which I could say and now we're live, it tells you over here that it's being live streamed. And it's,
So you're right.
yeah.
Put it in pause.
So what I do now is I can stop video.
determine whether a quorum exists.
Yes.
There's 3 out of 4 of us, so a quorum exists. Review and approve the minutes of the 9/12/23 hearing and the 9/12/23 meeting. You guys,
I make a motion to approve them as written.
Second.
all in favor? Okay. So we have one order of new business that we're gonna get to before we get to the hearings, and that is what we right here, Charles, it's about having the ability to participate remotely, the way the select board does. And because we can, then audience members, remote audience members can participate too, is that correct?
So the way that the select board, policy is set up is if one board member is unable to attend in person and they are going to participate remotely, which if Cheryl is going to participate remotely, you can then open up the meeting for other participants to participate remotely. If she is not participating remotely and you don't have another board member with remote participation, then the meeting has to be held in person without the visitors through Zoom being able to.
Okay, so it's only with another board member. It's not, for instance, if the code enforcement officer is participating, it wouldn't count. for
So that's the select board policy. And I would suggest that you follow the policy similar, but if you want to make exceptions, that's up to the board's discretion to do that.
Okay. So you're familiar.
Cheryl has her hand up. Stevens on here,
And we know that because,
because I could see
yeah,
that
but
she's.
we'll see, that's the other problem. Who's gonna monitor?
So
that.
my suggestion would be is if she is remotely and she's asking to speak, then you know, you guys figure it out as a board what you want to do. And if the decision is made that you want to allow remote participation, then I'll stay for the entire meeting and oversee the computer to allow that to happen. But do you want to allow her to talk to see what she says?
I was thinking that we do it at the next meeting. What do you guys think?
Well, if she's prepared to participate in this one.
I don't know, the only thing I think is that, well, if it's not broken, don't fix it. And also I have a critical fire training at 7 o'clock. If we have a quorum, I don't know what, you know.
Do you wanna table it then?
I'm just saying, you asked what I would think about it, and those are the only thoughts. What's the benefit at this point of having her remotely if we have a quorum? And, you know, yeah, maybe table it until the next time and we work out what we're gonna have for a policy. And it seems like once we have a board member, we also open up the door to other people,
Right,
right? So
Yeah.
do we need to, it sounds like we need a policy of who that is. Is it other town officials? Is it is it the building inspector?
okay. Let's table it.
Take down the road.
Pick it on the road.
Okay, so we'll save it for the next. So the next order of business is the hearing on the Zog and Zog Swafford application for a variance for practical difficulty for 12 Zog Lane.
I've always heard it as Zog.
Zog, I'm sorry, so sorry to mispronounce it. Zog,
Is it so?
is it Zog? So
It is.
sorry.
Thank you.
Conflict of interest or bias?
Nope.
I have none. All right, proper notice is given. Yep, from the file provided and kept by the town, it is apparent that proper notice has been given to the parties directly concerned, the public, abutters, through newspaper advertisement, by mail, and by public posting virtually and actually of the agenda and packet for the meeting. Summarize appeal. The owners of lot 104084 have requested a variance from the side setback requirements owing to practical difficulties. The established jurisdiction, type of review and role of our board. The board's jurisdiction to hear the appeal comes from MRS 30-A, section 4353, and TOCI zoning ordinance, section 603. Established standing of applicants. The applicants have provided documents establishing ownership of the properties in question. Review application is completeness and payment of fees. The town has confirmed that the applicants have paid all applicable fees. So next we talk about the rules of procedure, including the possibility of site visit. But before we start the hearing, I'd like to read aloud zoning ordinance section 204.1.d.3, which covers this appeal, and ask Alex and Nadia if you would like to come up to this point. We just have a few questions
Sure.
to ask before we start
Stand at the table there?
right there, but Chip says not too close.
Yeah, go behind the chair, because if you stand any closer, it's probably gonna be your chest or,
You gotta use the other one.
Oh, sorry.
Yeah.
well,
But you still have to stand behind that chair.
Yeah, just.
No. So how far away?
once I'll make sure that this space is visible. So back, I would stand between those two tables. There we go. Now try saying something.
Hello,
Maybe a little.
hello, can you hear me? Testing, 1, 2. Okay,
Okay, so. So zoning ordinance 204.1D3 states that the minimum side setback required for all structures in the island residential district that are more than 1.5 acres in size or that were created on or after August 1st, 1975 is 30 feet for a combined width of at least 65 feet. So do you know how many acres the property is, the lot is?
It's over 1.5 acres.
when you say combined of 65 feet, is that
So if
adding
you,
both sides?
yes. So if one side is 5 feet, but the other side is 150 feet, as long as it equals or exceeds 60 feet,
Yeah, that's not how it works.
65 feet.
That's not how it works. Under that criteria, which is for lots after 1975, and I think this one.
No,
Before?
no,
Well, the
it's,
35 is, the minimum is 30, and then the two of them have to add up to 65.
combined width of at least 65 feet.
Right. So
Okay,
that means
but
that one
Charles?
is 35, the other minimum has to be 30.
no, it's a combined width of at least 65 feet.
That's right.
So
The minimum of setback on one side is 30, and then the other side could be 35, it could be 45, it could be 55, it could be
okay,
65.
we'll let them
I have-
answer the question, but
But you understand, it is not that you can have 5 on one side and 150 on the other. The 30 that is the number mentioned first is the minimum size on one side has to be 30 for
okay,
that to
well,
apply.
let's let them answer the question.
Well,
how
okay,
many
this
acres-
isn't, this is actually right here in our zoning book.
I got it. This is our zoning law,
Right.
right? Our
And to
ordinance.
apply our zoning to the facts in to understand what that rule is. That rule is 30 on, it's the minimum is 30 on this side, and the other one has to be 35. Or larger.
That's not what it says.
That's exactly what it
No,
says.
it doesn't say that. What does it say then? 30 feet. Combined with at least 65 feet.
I just go by what's on each side, so I'm not from,
That's exactly what our ordinance says.
Okay, so that's a printed handout that you have there, right?
Right,
So do you have your actual ordinance that has?
it's the actual ordinance,
No, that's a copy that you've made right here.
right here.
We actually have. Okay, the following minimum setbacks are required for all lots in the Island Residential District that are less than 1.5 acres and that were created on or before July 31st.
It doesn't apply.
Okay,
We're talking about the one,
We were trying to establish that whether it applied. So if you could,
well, get me to the point where this is in the Island Residential District.
yes,
yes.
203,
There we go.
okay,
So right above, it, the following minimum setbacks are required for all structures in the Island Residential District that are more than 1.5 acres in size or that were created on or after August 1st, 1975, except that sheds and driveways are permitted.
there,
55 feet side, 30 feet, combined with at least 65. So if you take
Combined.
D, the following minimum set, if we look at it as a mathematical equation,
which,
D, capital D, period, the following minimum setback, okay? And then we go to 1, 2, 3, 4, which is under. When we get to 3, side, 30 feet, that's referring back to D, the language in D, after the capital letter D, the following minimum. So the side is a minimum of 30 feet combined with at least 65 feet. I don't, what appears to be totally lucidly clear to you, to me, I don't understand.
I don't understand it either.
That's not the way that reads. This is written
so
by,
you're saying 30 and 35 are the minimum.
30.
I'm saying that one side has to be 30, the other has to be
No, it has
35
to
or
be
greater.
30 and 35 because it's combined with of at least 65 feet.
So 30 on one side, minimum of 35 on the other.
Yes, 35 or greater on the other side.
Sure.
But you can't have 5 and 150, which was the example that you gave.
Well, that's because that's what it says in English. You,
Okay. I did score in the 85th percentile of the LSAT, and I did gain admission to several law schools. Okay, before I decided I didn't want to do that because I really love building houses, but I don't like arguing about this.
okay,
If
then
this,
let's
if
not
you
argue.
don't, if you don't
Let's just
understand
go-
this right here, I've located buildings on this island.
Okay, Charles, let's.
I've located them with the assistance of
Okay.
Ron Tosher, a master builder, okay?
Yep, Charles, okay, let's take it down a notch. Let's just then proceed with the hearing.
So what's your understanding of it, Alex?
I'm so confused right now. I was told initially, from the code enforcer, before she did a little more research, that the combined had to be more than 65 feet. And if it meant that there was 10 on one side, there had to be at least 55 on the other to get to 65 feet. That's what it initially said. Then she came back.
Then she called me and asked me to interpret the code
Okay,
for
so
her.
I'm not sure what.
She contacted both of us and I had a conversation with her.
No, I'm just saying, you asked the question, so I'm just
Yeah.
trying to answer the question.
Right.
So that's what I was told. And that's when I pulled out
Right,
from an application because we were supposed to be all set. 3 days later, after I guess talking to you or whoever, you informed me that, no, we do need to go through this process. So that's my understanding, that's all I know besides what you guys are trying to hash out.
It's why we're here today.
Right.
The cottage is located, it was previously located prior to any of these codes, closer than the later setback requirements. So that's why we're here. It's
Exactly.
exactly that reason.
right. So it still falls under D. That are more than 1.5 acres in size or that were created on or after August 1st, 1975. So
Yes,
the order-
exactly. But the ordinance says that the minimum one side is, and so they need a variance and that's why they're here.
Yes, correct.
So can we just move off of the 65 feet and try to get to
Yeah.
the
Okay.
actual numbers of where?
Okay, so do you want to describe your,
So basically, we're trying to build 4-foot addition, come off the front of the house, go to the ocean side. Plenty of room on the front, side and back. On one side in question is only 7 feet. Again, this was put in years and years and years ago. So the addition coming forward does not get any closer to the sideline than what it already is. So we're not getting close to the hill, so that's.
You're not increasing the nonconformity of a non-conforming structure.
Correct, exactly.
That's it.
and how big is your addition?
It's a 4 foot of just the kitchen, with the adjoining deck there.
Well, the deck itself is all existing, has
Yes,
to be rebuilt, so it's gonna be 4 by 12, so 48
4 by
square.
48 square feet.
correct.
Okay, do you read the letter? We have one letter from John Lang, who is a direct abutter, I guess, on 2 sides. Should we read this letter? No?
What's the next application? The application.
So yesterday, John Lang sent me, here, you can read it.
Sure. This is a letter from, I just saw for the first time today, having been away. And it's obviously it's from John Lang, and a butter of 12. So Lane, sorry, regarding the application for a variance for side setback requirements, public hearing February 6th, today, 2004. Zoning district, residential, Island residential. This letter is notified by the Board of Adjustments and Appeals, select board members, planning board members, and code enforcement officer of a discrepancy in the property boundaries of the applicant property. When I took title up to the property at 11 Zog Lane, I constantly mispronounce that, in 2003, I commissioned a survey. Through the survey, we discovered there had been an error in the recording of the deed at the time of the property was transferred from the applicant's grandfather to my father in 1954. We hired legal counsel to research the relevant deeds to discover when and how the error occurred. Once defined, I discussed the discrepancy with the applicant's father, whereupon he acknowledged the facts, but had recently transferred legal ownership to his daughters. We then presented the findings to the new owners and requested they sign a correcting deed to clear up the matter. However, they were unwilling to acknowledge the facts and sign the document. Given the applicant has requested cooperation from abutters for the board to approve the variance, I took the opportunity to present and request again that the applicant sign and notarize the correcting deed. As of this writing, which is not dated, as of this writing, the applicant has not yet complied with this request, despite my asking twice and offering to pay the necessary legal and recording fees. I simply wish to clear up this cloud on my title, which acknowledges the existing historic property lines as we both know to be true and correct. The parcel in question is essentially most of my backyard and measures 140 feet by 73 by 126 by 72. It can be viewed on the applicant's document in the survey on page 16 as the flag portion at the northeast corner of their property, traversing alongside and near the stone wall on the survey. I am also including an excerpt from my survey, which defines the parcel in question. My two properties abut the applicant's property on two sides, thus we are impacted by the setback code violation more than any other neighbor. Further, if the parcel in question was in my deed as it should have been, the application may even violate the front setback requirement in addition to the side setback. I hereby object to the variance request. Should the applicant comply with my request and sign the appropriate correcting deed, I will withdraw the objection. Signed, sincerely, John Lang. And included in it was a drawing of the piece of property in question as it relates to the applicant's property and his property.
So you had a chance to review this?
So I will just say that, this property that he's talking about has got nothing to do with the property that we're talking about the variance for. I mean, they don't, it doesn't, affect the setback from the front.
It's a different boundary line.
It's a different boundary line.
Different.
It's completely different piece of property than what we're here for.
I guess my concern, having gone over all this material, is I don't know what the setback is between Ron's proposed piece of property that he belongs and to the front of the building that we're talking about.
69 feet.
But it really information if it's helpful.
Okay, good, because the diagram,
It's totally
the plot,
unclear on the
you
diagram.
can't really see it. So if you could walk us through
Sure.
where John says, or
Can you bring this up to you?
yeah,
I can bring it back. This is, I can show it to all of you. This is, the cottage is here.
Yep.
This is where the house is. It's 10 feet is the distance to the line, which is what we're talking about the variance for. Mr. Lang's question is about parcel 1, which is down here. This distance from this stone wall, which is where the extension would go, would be right to the stone wall. All the way to here is 69 feet, so it's not, yeah, it's
Okay.
not even any limitations under any.
In his drawing, the one that we got in the middle,
yeah.
he was indicating that the boundary was vague.
No, he said the stone wall, but it's confusing because what he means
two
is
stone
parcel 1.
Oh, okay, because there are no stone walls, and he said the flag portion
Right.
of the stone wall, which can,
Yeah, if you read his deed portion, it refers very specifically to this
This is
portion.
the drawing that you submitted to us. We're
Correct.
talking about this parcel, not that parcel.
correct,
And you're
so,
talking 69 feet. In there.
Correct,
Okay.
yes.
Yeah.
So that's,
Very good.
yes.
yeah,
Just-
okay.
Yeah. And I brought some other notes. I can leave this with you if it's helpful as well.
That would be good.
What's that?
If you'd like.
Oh,
Yeah.
gotcha.
Sure, absolutely. I brought cousins on. I only wrote on one, but. So I just, if I can make some comments, I just want to note a couple
Yes.
things.
Please.
So, as Alex was saying, the specific issue brought up has no linkage with the boundary that we're looking for a variance on. It's a completely separate line. Also, in the letter, in the time period referenced, the Zog family retained legal counsel that found that the registered deeds as submitted with this application were in good order. Mr. Lang's letter implies there might be an issue on the boundary, but as you can see, if it were taken into account as that parcel being part of his property, but as you can see, it's beyond any of the setbacks, whether it's front, side, rear, etc. So it does not, that is not an issue as well. And I also brought the communications back and forth because I think in his communication to the Zog family, he registered that he was actually quite positive on the works that they were doing. His issue was a totally separate issue, which is not an issue that falls within the jurisdiction of this board. So it was an opportunity to back pressure differently,
I
but
think I would. Not really.
Okay. Any other questions for the applicants? And then we can move on to presentation. We don't have any abutters here, I don't think.
Sort
Are you in a butter, John?
Sort
Okay, so if you have you a comment, if you, then, okay, would you want to step up and say that? Would you mind? That we have to. Just state your name and that you're in a butter.
We should have some, is this the right mark on the floor, like?
Yeah.
Where to stand?
John Corson, Hamilton Hotel Road for one property, which is the abutting property. And we have no problem with this application. Is that what you are looking for?
Pretty
I
much.
think so.
Do you sing anything?
What?
Sing?
That might turn the whole thing.
I do.
Okay, so. Anyone else directly affected or members of the public who would like to say something? Or other board members? Come on up, Bob.
No need to dance.
Oh, he's walking really well.
Get back.
There you go.
Yeah.
You're tall.
Two just minor points, having gone through the 31.
How to
30
identify yourself.
Robert Ernest, 351 North Road, speaking tonight as a member of the public and a former planning board member. Just wanted to make two slight comments that may help your thinking or may not. If you read the language that was being discussed earlier, 30, but both equaling 65. 31 is a minimum of 30, therefore the other one would only have to be 34. 30 and 35, 30 and 170 would all meet the requirement, but 31 plus something has to equal 65 and 32. So that's one point. And then the other one, this one you might want to talk to a lawyer about, but the statement was made by one of you earlier that this project does not increase the nonconformity of the property. I would argue that it does. You have a nonconformity now of a 10-foot setback that is for X feet. And now that nonconformity is proposed to be 4 feet long.
Yes.
So it is technically increasing the nonconformity. Minor issue. I'm not proposing anything other than just trying to help read the ordinances.
I agree.
Thank you.
And I would like to address that. I've been on either the planning board or the Board of Adjustment and Appeals for almost 20 years. And if we were interpreting it incorrectly, then it has been interpreted incorrectly for 20 years.
Point taken.
So
Charles, I'm not arguing with you. Why don't we?
I wasn't arguing. I was making a response to
Very good. Okay.
what he had to say. And of course, that was on Board of Adjustment Appeals with John Wilson as the chair of the board, and many other people applied to the additions that were done on Get Radio Martin's house and numerous other properties. So it would be good for us to actually meet with the planning board and to look into this question, because it has been the long term, interpretation of this that technically square footage of it is, and this has been the way we traditionally have done it.
exactly.
I'm not saying that he's
No,
not right, that he's not right.
But I think it's another one of the ordinances that we've run into some issues with. So,
Right.
thank you. Okay, so any other comments, questions, rebuttal? Do you guys have, I don't think we have further questions for you. Do we? You have
We
further
need to
questions?
reach the 6 points where we,
Well, we were gonna go through, we can go through those.
do we just pass on that?
No, I think in discussion we'll do that. Since you know that you have to meet all 6 criteria. I was gonna read part in deliberations, and you have responded to them. Did you go to easy one when you guys?
As they,
Okay, so, sorry. Okay, so it says pursuant to 38 MRSA section 4352(4)(c), the Board of Adjustment and Appeals may grant a variance only when strict application of the ordinance to the applicant and the applicant's property would cause a practical difficulty, and when the following conditions exist. Practical difficulty shall mean that the strict application of the ordinance to the property precludes the ability of the petitioner to pursue a use permitted in the zoning district in which the property is located and results in significant economic injury to the petitioner. So, the first part is A, the need for a variance is due to the unique circumstances of the property and not to the general conditions of the neighborhood.
It's the pre-existing building that was there prior to the ordinance. So the location is due to previously existing, so any addition to it, which we try to make as minimal as possible, would require this variance.
Is there any way you could put this 48 square feet farther in front so that it does not increase the non-conformity of the structure?
No, because the way the building is set up, that's where the kitchen sits, and it's a kitchen, it's just adding room for the appliances in the kitchen that are no longer the same size as when the house was built. And so it's making room for the refrigerator and other things that are bigger. So it's not there's no other place to put those unless you put them on, on the front porch.
no, personally, I think it's amazing that the applications come in with such a small request for increase. And I don't know if that was delivered or not.
It was.
It's amazing. It's small.
It was purposeful to try to make it as,
48 square feet.
yeah. It was purposeful.
And that's not even the size of most rooms. So it's really just to increase the walking around
The kitchen area.
room. Is it? I noticed that there's a wheelchair ramp included in this application as well. Is the increase in area needed for someone with a disability to get around?
It would certainly help, as well. Both of the, regular, residents there are in their mid-70s. They don't currently use one, but the applicant, relative was using a wheelchair, so it's really anticipate, the potential of needing as well.
Right, to meet the requirements for wider doorways and wider spaces from appliance to wall. So that is a factor in this as well. Okay, so next part is B, the granting of a variance will not produce an undesirable change in the character of the neighborhood and will not unreasonably detrimentally affect the use of market value of abutting property.
We believe that this would be a positive for the neighborhood. It's, you know, renovating this cottage that needs renovation work and even in the one conflicting letter, they acknowledge that these improvements would be a positive.
Okay, practical, part C is the practical difficulty is not the result of action taken by the applicant or prior.
Correct, there's a previously existing cottage from the 1920s.
So D, no other feasible alternative to a variance is available to the petitioner.
Correct. The cottage can't be expanded in a way that doesn't affect it to, you know, achieve the required result, and the cottage is pre-existing, so without, you know, building an entirely new home, which would be economically not feasible, there's not an alternative.
You're basically filling in a screen porch too, is that?
That's out of the front.
Yeah, there was previously a deck already there.
Oh, okay.
We're not expanding the footprint.
Yeah, you're not expanding, except for this 48 square feet, you are not expanding.
It's just out of the room.
Yeah.
That's correct.
Yeah. Okay, so, what's the E? E, the granting of a variance will not unreasonably adversely affect the natural environment.
No, as you see, there's very minimal.
Right, you're not adding back. Okay, F, the property is not located in whole or in part in the shoreland areas as described in Title 38, Section 435.
Correct, nothing appears within the 150 feet.
Okay. Okay, do we have any, would you like to make any additional comments about this?
Unless you need anything.
Anyone from the audience? Okay, well, why don't we close this portion to the public and move, make a motion, close it. Even though our lawyer-
I make a motion that we close it.
Okay, all in favor? All righty, so then we'll just go on to the deliberative. Yes, you did that. Okay. So we do have the front setback cleared up.
Yes, that's the
What do
big,
you think, Charlie? We do have the front setback issue cleared up.
Mhm.
So all we're now talking about is this 48 square foot addition, which will increase the non-conformity of the building
4 feet.
by 4 feet.
Mhm. But we're not impinge on that line anymore.
Right. Well, I think they've met all before.
Thinking of it as square foot.
30.
Doesn't matter. Okay, let's go ahead, let's do it, let's make it happen.
Yep.
Let's
I
try
think
it.
they've met all 4 criteria. Oh, 6 criteria. All
Right.
criteria.
Okay, wrap them up.
State has 4, and we have 6.
Yeah, especially, like, I would be in favor because they're also increasing it owing to someone with disabilities or anticipating that someone will have a disability.
That, and I think the minimalist approach that they've done,
Right, it's a sensible. What do you,
Yeah,
very simple. Yep, okay.
okay, so we have. Just looking down that part. Okay, so do you want to draft a motion? For that?
okay, remind me what the first one is.
Well, we have to go through and see if we met the 6 criteria.
Right.
So let me read them again. So the first one is the need for a variance is due to the unique circumstances of the property and not to the general conditions of the neighborhood.
I make a motion to acknowledge that the need for the variance is not because of any actions of them, because the building was cited before our zoning was adopted.
I would second that.
All in favor?
Okay, so are we capturing this as we speak?
Well. I'm not.
I mean,
He's going back over.
Usually you write it down.
He's getting very cavalier about it.
Yes,
His
sir.
memory's improved incredibly.
You might want to repeat it because when he was speaking, your mouth was covered and it might be a little.
Was my mouth
difficult.
Speak into your bounds.
Okay, I make a motion
Here.
that they satisfied that the need for a variance is due to the unique circumstances of the property and not to the general conditions in the neighborhood. The building was sited and built before the adoption of the ordinance.
Yeah, that's not, I mean, also it's because not all the properties on that road are the same size. So it's different.
Well, don't mumble.
Anyway, okay. So,
That was a repeat, we've already voted.
yes, okay, so we're set. So part B is the granting of a variance will not produce an undesirable change in the character of the neighborhood and will not unreasonably detrimentally affect the use or market value of abutting properties.
I make a motion that that is correct, that it is a minimal addition to the property and that it will not, that it will meet that criteria.
Second, all in favor? Okay. If you want to do the next.
Sure, practical difficulty is not the result of action taken by the applicant or a prior owner. I would make a motion that, get the language. That the practical difficulty was not the result of any action on the part of the applicant or prior owner.
A second.
Okay?
Okay.
There's no other feasible alternative to the variance is available to the petitioner. And I would make a motion that there is no other feasible alternative to the variance that is available to the petitioner.
One
I
second.
would second that motion.
All in favor?
You want to take E?
I don't think he has it. Did you have the?
Oh,
What about Sam?
I'm
You go.
talking too much, isn't it?
I'll take it. Okay, so E, the granting of a variance will not unreasonably adversely affect the natural environment. I would make a motion that the applicant has proven that the granting of this variance will not unreasonably adversely affect the natural environment.
Second,
Third?
all in favor?
And lastly, the property is not located in whole or in part within the shoreline area, as described in Title 38, Section 435. And I would make a motion that the property is not located in whole or in part within the shoreline zone.
Second, seconded, all in favor? Okay. So. The Board of Adjustment and Appeals voted to approve a variance on the basis of practical difficulty for lot 104, 84, 084.
104, yeah, lot.
084. Vote was 3-0. If granted, this variance is not effective until it is recorded using the form provided by the board in the Cumberland County Registry of Deeds. The recording responsibility lies with the applicant and must be done within 90 days after the final decision. And the citation is 38 MRS section 4353. So you'll receive a form, or the Zoos will receive the form in the mail, and you have 90 days to file it. And if you don't file it, then you have to go through this process again.
That's correct.
Yeah, please file. So the next up is
Thank you.
Yes, thank you.
Thank you.
And next up, we have a request for a variance from the side setback for practical difficulty on lots IO 4046 and IO 4047. And the applicants are Jennifer Hubble, and you are,
My name is Richard Hubble. I'm Jennifer's husband, and she has designated me in writing to represent her at this meeting tonight for the project manager.
okay,
Half the project funder.
the first, alrighty. So first, we have to determine whether there's a conflict of interest. Do we have any conflict of interest for guys? Okay,
Do you still have that pickup?
Yes.
Some of a pickup about 20 years ago.
There's right by.
okay. Next is proper notices given and from the file provided and kept by the town. It is apparent that proper notice has been given to the parties directly concerned, the public, abutters through newspaper advertisement by mail and by public posting virtually and actually of the agenda and packet for the meeting. Summarize the appeal. The owner of lots IO 4046 and IO 4047 have requested a variance from the side setback requirements owing to practical difficulty. Established jurisdiction, type of review and role of our board. The board's jurisdiction to hear the appeal comes from MRS 30-A, section 4353. And TOPI zoning ordinance section 603, established standing of applicants. The applicants have provided documents establishing ownership of the properties in question. Review application to completeness and payment of fees. Town has confirmed that the applicants have paid all applicable fees. The explanation of the rules of procedure are just the same as the previous hearing, since it's also a hearing for a variance owing to practical difficulty. So we'll start with a presentation by the applicant.
Okay. Thank you very much. I submitted an application back a little over a month ago, and we included in that drawings and so forth, and I've also brought along larger scale drawings if anybody has any additional questions. I have copies here. So with me tonight, I have Bruce Butler, our architect, and Eric Weevil, who's our contractor. So they're here to, there's some questions that I can't answer, so we have asked to do that for them. I think we pretty well laid out a number of the items here, and I guess we can discuss them further as we go through the various 6 criteria. So I thought maybe rather than reading all that over again, with your permission, I would just sort of elaborate on a couple of key things about this particular project. So I think that the first goal of this was that we wanted to take a project, a building that has been in disrepair for many years. It's been unoccupied and unfit for habitation for the last 12 years or so since we bought it. Taken us a while to figure out what to do with it, but we haven't come up with a plan for it. And so our idea was to try to make this habitable by making an addition to it that would include the basic utilities, kitchen, bathroom, so forth, as well as a code compliant staircase to get to both sections of the existing structure, so that we would then have essentially a year-round structure, the new structure, and then it would be attached to and serve the existing structure, would then allow an additional expansion for summer use, since it's primarily summertime. Not we all plan on living in it year round. We'll make it so it could be. That's the key thing we wanted to do, and so we engaged Bruce to help us figure out how to do this. They came up with this plan, which did this in what we felt was the most effective, efficient way to do it. The least amount of space to be constructed, the least amount of land to be used, the least amount of materials to be used. The only issue we have, of course, is that the building itself is only, the existing building is only 7 feet from the lot line, this closest point. And in order to do the plan, when we laid it out, included the line and so forth, we basically would be at our closest point about 11 feet from the lot line. We examined what we would need to do to make this 20 feet away, so that the lot line. In order to be able to do what we wanted to do, which was to have this 4-bedroom seasonal year-round facility, we would need to build a connecting structure that would connect the 2 floors to make this thing work and we wanted it to work. And that would require roughly $35,000 attached to the application. Is the estimate that the contractor here put together to explain what we have to do in order to make this one building, to make an addition, serve the old building as well. So that, from our standpoint, that was practical difficulty, dollars and cents, at least $35,000. If we were to rebuild the structure entirely separately, we're probably talking like $100,000 more than this. So from that standpoint, we felt that was significant difficult in terms of achieving what we wanted to do. The new structure, the new addition, would in fact not be 11 feet. It's not 20. It's still, as the discussion has been earlier, I guess it continues the violation of the setback requirements, but it is clear that it's no closer than, in fact, it's further from the lot line than existing. And I think that pretty much sums up why we're trying to do what we're doing and why we need the variance, why we feel that it's not the impact on the community. In fact, I'm not aware that I've contacted all your butters and all close neighbors, and I am not aware of any negative comments that have been received by the board. I've not received any. And I have 3 letters that have been supported, have been given to the chair in support of this, primarily because they look at it as being taking what really dilapidated structure and converting it into a useful structure that would be in keeping with the neighborhood. And they would very much like to see us put this project together, create a much better looking project, a much better residents in the neighborhood. So with that, I expect we have some questions on some other aspects of the criteria, but I think we've covered those in writing, but I'd be glad to elaborate on them or Bruce or Eric elaborate. So that covers basic thoughts. As I said, if you want to look at these a little bit closer, I think you've got the drawings there.
Got the drawings.
You know,
Yes, we have.
they're enlarged.
We're gonna ask the questions, how do we get into them when we deal with each of those?
Well, we get into them when we deal with each of the things and we discuss it among
That's what I would.
them. Okay,
Yeah.
so
Well, Charles, do you want to ask anything now or wait till we get to
the specific 6 criteria they have. Have you?
do we just need to go through, is everything paid and everything?
I
So
I
we'll have to
think
wait,
I
or-
did that. I did that.
And
Thank you for that. Okay, so we have no specific questions, I mean, general questions.
Okay, I was gonna say.
We will have specific questions when we go through the criteria
Right.
that you have to meet. So we're opening it up to abutters first. Any questions? Other members of other boards? Anyone? Did anyone have questions in this part? No. We have no abutters, or John, are you in a butter for this one too? Okay, but we have received letters from 3 abutters, all of whom support the project.
I would ask one question, regarding this issue about, have you heard it all from the Reeds?
I did talk to, Cookie Reed, who owns the immediate lot that's, I would say behind the house, but it still has a common lot line that's an issue here. Currently the lot's unused, and it's a pretty small little lot, as I think I explained in the thing. I wouldn't say he was, supportive enough of it to write a letter saying it's really nice, but I don't think he felt that, there was any particular significant impact. He has no current plans to do anything with the lot. He has a well in the middle of it. And we respected that in terms of anything we would do in terms of our own well, septic tank, all that kind of stuff. So I didn't know what that is.
I guess I have a question regarding that. Who owns the camp right in behind the existing building? The garage and the camp?
That's owned by Sherry Peck and her sister.
And there's land between that and,
There's a 60-foot wide lot. If we look at this lot here,
it doesn't show that.
it doesn't, but if you see these lots of 60 feet, 60 feet, there's a subdivision built here, and 16 lot subdivision laid out in
So there's another 60
1902.
feet here.
There's a 60-foot wide lot here.
Okay, and that's the Reeds piece.
That's the Reed piece. And then there's another, let's see, there are another 3 lots up here that have one house on them. That has one house on it.
Okay, so the one that when I'm sitting here on the road and looking back at the existing structure.
Yep.
I think of a camp that's not.
Well, yeah, it's one of the common cottages that have been built on the island by Mr. Hamilton back, 100 years ago.
So the Reeds is there and you're saying,
This would be,
X,
Yes, the PEX is here. This lot, that's 60 feet, so you go 60 feet here, there's a lot line there, and their house is right in here. And then they have a little garage next to it, and they have they have backland with a septic.
okay. So all these lots in here in this development were original.
They're all little 60 footers, yeah. And most of them,
So
with the exception of the Reed lot, most of them have been combined.
no, 6 o'clock, but
adding to that, I'm curious, ever any effort made to try to acquire the Reeds?
Yes, 10 years ago, I asked about it, didn't get a
Thank you.
response. When I talked to Cookie in the last year, we're getting ready to put this, before you. He did not offer that up.
Okay,
I thought that would make life a lot easier.
it sure would have.
Well, I agree. He has have a right to one going.
And it has an artesian well on it?
No, his lot has a surface well on it. This lot, that we have has a surface and an enhanced well on it, which we're gonna be discontinuing. And last summer we drilled an artesian well, or it isn't the artesian, but it's a drilled well that's in the corner of this lot.
Yeah, I noticed it when I was looking from the road. It's right there.
Yeah, that's right there. Right.
so it's right
in the corner.
here.
And that's been set up to be, at least 100 feet from the septic field that we've had engineered.
Oh, where's the septic? So the septic field is already in?
No, we just had an engineer, and I want to know where I can fit it. And so it's right in this area, right?
So it's in the lot next
It's in the-
door.
Yeah, it's still a common ownership, yeah,
It,
but
it's not, the lots are not combined, though.
they aren't, but for purposes of, building and the like, they would be considered to be, but they could never be separated again.
They could never be separated.
Well, because they separate them again,
Joined again.
they'd be less than a minimum lot size, and it'd be a new thing, and you can't. do
Become a
that.
non-conforming lot.
Right, well,
That's what
It
people
would
would
became
not.
a non-conforming.
it's
This is a
not conforming lot now, the three of them together are not.
Right, no. Say that
Right,
these
none of
are-
them are non-conforming lots, but
Right.
they're all non-conforming lots of record.
But it really isn't our business where the septic system is.
Right,
It's like-
just,
No,
no,
My-
no,
my
no, no,
mo- My stepmother's house on Cousins Island, she has a combined septic with a neighbor who
Yeah.
originally
Okay.
owned both properties. They are now separate properties, but they do have the
Right, they
septic.
have some kind of agreement, yeah.
As well as, the old cart road has a bunch of combined wells and stuff like that, so it's not, this is not our.
That's not
purpose.
really, I didn't bring it up because it's not really an issue.
That's right.
no. Okay, so. Yeah. Question for them. That's good. Teddy in the bottom? Okay. Yes, okay, do you want to go on to then? The criteria?
Mhm.
Okay, since we have no other comments.
Comments about this project?
Yes, would you like?
I would like to make one as the neighbor of Capsule. I think it's an awesome project and it's gonna uplift the neighborhood. And from what was gonna become another swamp and just overgrown and a
Oh.
rotten house.
Teddy, you're supposed to stand up. You have
Oh,
to
yeah.
stand up. And identify yourself and give your address. Sorry.
No.
But the exit of the park.
Put some makeup on.
Just gotta listen to Julie.
Just here in support of, the project down on Capsule.
And Teddy? and you-
Teddy Holton, one Capsule, representing Ruth Holton and Teddy Holton, and, I think it's a boon to the neighborhood. I'm glad to see that health being saved. Because the other alternatives, it was gonna turn into, collapse house, so. That's all.
Okay,
Thank you.
thank you.
Thank you.
Go over your 6 criteria. Do you want to? Okay. So. First one is the need for a variance is due to the unique circumstances of the property and not to the general conditions of the neighborhood.
Right, so, as I explained it here, I mean, this is an existing structure, it's built 7 feet from the lot line. This, all the issues have to do only with this particular issue, It's nothing, the neighborhood has nothing to do with this, so it's, um. The only issue really is the condition of the existing building, the location of the existing building, the location of the addition that would be added to it.
Okay, the general conditions of the neighborhood include the fact that this neighborhood consists largely of non-conforming lots. You just said yourself that most of them are non-conforming lots of record. So in that case, your lot is not unique. It's just like all the other ones, or most of the other ones in this neighborhood. So
I'm not sure I understand the point, but I mean, I
the
guess
need for a variance is due to the unique circumstances of the property and not to the general conditions of the neighborhood. It's not,
it only has to do with this particular property, this house. It's not because of somebody else close to me or whatever. It's just this particular lot and where this house is situated on it. The fact that there are other non-conforming lots and non-conforming dwellings in the neighborhood really has no bearing on this particular situation. It doesn't make it any more or less non-conforming. I don't believe it. Is that the answer to the question?
Okay. The granting of the variance will not produce an undesirable change in the character of the neighborhood and will not unreasonably detrimentally affect the use or market value of abutting property.
Right, I think that's been particularly attested to by the comments from the 3 written comments and the comments made here tonight, that taking what is a dilapidated structure and making it useful, and making it fit into a neighborhood which is all seasonal dwellings, will be an enhancement to the neighborhood. And the neighbors have all said they think that's the case.
Again, I raise this point of this cottage is sitting back, obviously now more than 60 feet from your property line into the next 60-foot wide lot. It would appear that their only view, is across, well, the only view afforded them from back there is your property. It's open.
It might appear that way. I can clarify that they have actually a better view that's not across that part of the land.
But it is, you refer to, is it in this one or another one, you refer to that as,
I referred to that relative to, well, what I did say was that this addition, relative to the lot that is directly, abutting,
yeah, but nothing can be done with that lot. But
well, I'm not, that's not entirely true, because, there's still a buildable envelope, just barely. It would be difficult, it would be a challenge, but that, even if, well, the way I explained it here was that the building were built, the addition would be 26 feet
That's what
along
you said,
that
yeah.
property line, okay? And so if it were moved 9 feet further, so it would be 20 feet away, they would have the same impact on the view of somebody, from somebody behind it.
right, but you wouldn't have the setback problem.
That's correct, but the issue is you're talking about a lot that, if you're talking about the next cottage over, you're talking about a lot that is now, a building that's now 60 or 70 or 80 feet away, and now would be 89 feet away rather than 80 feet away. And it's the same view. What I would comment, if you look at this drawing here, is that for these people here, their view, their primary view from their porch is this way toward the ocean, and all this land is cleared. Yeah, I have a house here, my family summer cottage is here, but this, their view is primarily this way. They have trees out here, yes, they have trees here, and they trim some of them themselves. And they're trees, some of them here, and then there are trees in here which are just there. And, so I
thought,
okay.
Questions, Charles? Okay, so C is the practical difficulty is not the result of action taken by the applicant or prior owner.
Yeah, I think it's pretty clear the building was built probably 100 years ago. We don't know exactly when. It's been there right along, and it's with nothing that it's already that close to the lot line. There's nothing that they've done to make it any closer or to make the situation worse. In order to make the building useful, we'd either have to renovate it all inside itself, or we could build on the wrong side. It's usually easier to build alongside if we wanted a space that would have some season, shoulder season or winter use, if we chose to use it that way, which would be even harder to do in the existing structure given its construction. So the idea was to make sure we had something that was to be used more year round and meet all the code requirements that were needed and provide the kitchen and bathroom facilities, which would be easiest to do with an addition rather than trying to do it inside the existing structure.
Did you ever just think about building a new structure on the other lot?
Sure. In order to do what we want to do, we want to have a 4-bedroom house with, the space that we have in there. I think it's pretty clear that probably cost, I may have mentioned it here, I didn't do a full estimate, but it'd probably be $100,000 more expensive to build a building that's twice as big as this. It's twice as big as the proposed addition, because it's about the same size as the existing structure.
Have you thought about moving the existing structure to the lot 47?
I looked at that 10 years ago, and the estimate to do that was well over $30,000. There's a fireplace in it and so forth, so it would be, I mean, it's not saying it couldn't be done, but we'd have to add all that, you'd have to do that. And there's also some problems with the middle of the lot, which are caused by the town should be behind or the town of Cumberland. In the next lot over here, right here is the drainage ditch, which came from stormwater discharge from town culverts and town ditches that was allowed to run across here for the last 35 years. And we're now in negotiation with the town to build this project. But there's a certain limitation of what you can do in here because of what's there.
So if the culvert removed, would the limitation be removed as well?
No, because the water has to go somewhere. So the plan right now, it's been engineered over the last decade, is to reroute the drainage and provide a discharge to the beach that currently is just being done for nature. Across all of the lots that are there. Several properties involved, the water was just discharged without any regard to where it should go, and it cut its own way to the shore, which is where it's gonna go. The town, you know, does not have any ownership of that land across there, you know, the process of negotiating rights of way and so forth to do that construction. But in the meantime, the middle of the lot is sort of unbuildable because of seasonal stream bed. Plus, we're trying to make sure we reuse an existing building, that we can't, we'll not waste the building.
Okay, C, no other feasible alternative for the variance is available.
Right, so just earlier, we had the estimate that if we were to move the building, so to comply with the lot line, in order to have it serve the existing building, we would have additional construction expense to construct connecting structure. It's the product to piece of wouldn't be maybe butting at the corner, but and that two-story addition that you know use the both buildings effectively, which cost an extra $35,000. That's really the practical difficulty of doing this.
That actually isn't the definition of practical difficulties, but let's just talk about the fact that you are going, this current building, the lot already has an existing building, which our zoning ordinance allows you to rehab,
Yes.
rebuild,
That's correct.
and make, as long as you don't make it more non-conforming. You're suggesting that you are going to rehab this already non-conforming building and add, like, double the space, but also make that space non-conforming as well. And it doesn't matter if it's less non-conforming, it's still
Okay.
the key word is non-conforming.
We're not really rehabbing existing space, we're just using it, adding on to it. So it's not made it full rehab. It's gonna be seasonal, there's no facilities in it. We'll, you know, we repaired the underpinnings of it so far. We repair, you know, wiring, but we're not doing any rehab in that building. So we're building this additional piece to it, which will enhance the ability to use that building. And yes, I guess depending on how you define the non-conforming, this, I think Charles said earlier, there's been a history of saying that something is more non-conforming, that's acceptable. And that was I guess we were operating under that theory, that we weren't making it worse from the standpoint of making it any closer to the lot line, that would be acceptable, but I just.
And I can just, for section 110 of our ordinance's definitions, increase the non-conformity of a structure. Any change in a structure or property which causes further deviation from the dimensional standards, creating the non-conformity.
Yeah.
Such as, but not limited to, reduction in water body, tributary stream, or wetland setback distance, increase in lot coverage, or increase in height, structure. Property changes or structure expansions which either meet the dimensional standards or which cause no further increase in the linear extent of non-conformance of the existing structure shall not be considered to increase non-conformity. So,
Okay.
As I see it, what we're adding, is a new structure, a new non-conforming structure on a non-conforming lot.
Okay.
Do you agree with that? You're looking for a variance for that.
Well, I'm obviously looking for a variance. I wouldn't necessarily 100% agree with that. It depends, I guess if we have a, there's been a discussion here earlier. I don't know, you know, the different interpretations of how you deal with whether you're extending a non-conformity or increasing the non-conformity. And I, you know, both measures can be, I guess, could be acceptable depending on how one defines certain things. But I guess that's unfortunate, you know, that's your job to figure that out. I think, you know, there have been a lot of things built here, other places and so forth, where people have extended things, but not made the situation any worse in terms of how close it is to the lot line. And I guess that was sort of the understanding that we had, that would be a way of interpreting the issue about whether it's increasing in non-conformity. But I hear what you're saying as well, so it, you know, it depends on how one interprets that.
Would you read the tail end of that about the linear?
okay, so should we just, we can just go to the ordinance itself, so it's about non-lot regulations. Section 501, the use of any building, structure, or land which is made non-conforming by reason of the enactment of this ordinance, or which shall be made non-conforming by reason of a subsequent amendment, may be continued subject to the following provisions. 501.1A, repairs and alterations. A non-conforming building or structure may be altered, improved, repaired, or reconstructed. A non-conforming building or structure may be added to or expanded after obtaining a permit from the same permitting authority as that for a new structure, if such addition or expansion does not increase the non-conformity of the structure or expand the area of a non-conforming use. The number of square feet of floor area devoted to the non-conforming use may not be increased unless the Board of Adjustment of Appeals finds that the proposed expansion of the non-conforming use, which this is not enough, we're talking about a non-conforming, will not adversely affect other property in the same district and neighborhood, and that the granting of such approval by the board will not substantially depart from the intended purposes. So
is residential, is a residence a non-conforming use in the residential area?
no,
No.
the two, this is talking about two different things. Non-conforming use, which means like if you had a gas.
Yeah, I know exactly what it means.
Okay.
I'm asking the question. You read that
Right.
to apply these facts.
But
And this is a residence.
I know,
This
but
isn't- It's not a residence with a gas station attached to it.
it's a non-conforming building.
Yeah.
Or use.
Okay.
In this case, we're talking about a non-conforming building, so it can't be made more non-conforming. You can, our ordinances give you the right to repair, rebuild the existing building on the lot, but you can't increase the non-conformity unless we agree to it. So this
Fine.
not only increases the it doubles the non-conformity, because to say that it's 11 feet back now, the addition, it's still non-conforming. So,
And that's true. It's non-conforming. And I misspoke when I said non-conforming. The way that it was used in the past, it was if you're not increasing the intrusion into the setback. Ray Gilmartin was allowed to have a second bite of the apple and to put on, after he built, you know, a huge structure within the shoreland zone, he was allowed to add to that structure considerable amounts of square footage based on the fact that he wasn't getting any closer to the water. So,
Okay,
I'm just
Charlie,
saying
can I
that-
just interrupt and say?
I know where all the bodies are
Don't-
buried with this stuff, and I'm just saying, we have this thing, it is written as this code, and we are embodied to deviate from it. And I'm just saying, I disagree with you two and, you know,
Okay, you are
so,
free to.
and I'll
disagree,
die on
that's
that
fine,
hill.
But.
And I
what-
would like to get to the fire training in case somebody's house gets lights on fire tonight. So. I made myself clear. That's where I am, and that's how I will vote.
Okay,
And that's why we don't just have a bunch of written rules that apply. At some point, there gets a board gets to get in there, and I really do think that there is a long tradition, and you know.
Okay, but first of all, we're not precedent, so just because we voted yes for the past 3 times on a zoning ordinance owing to a variance for practical difficulty, it doesn't set a precedent.
No, it doesn't,
So,
but I
okay.
served on these boards and we, in the past, you know, and maybe somebody should, in the past, if there were no abutters and it was deemed that it was a good thing, we all said, we're not, you know, these codes aren't a suicide pact, we're not out to screw each other. My mother's house is like right on the property line, she was able to do that.
Okay, can we just zoom back, because actually the state, I can read you what the state's position on variance owing to practical difficulty is that a variance owing to practical difficulty is asking people to come before us and suspend the rules that this town has made. So we're saying, you know, those rules, not a big deal. So the state
And we
is
have
making,
consistently said that.
we have
And
not
you and I have
consistently,
consistently said
we
that.
have not always consistently.
We
said
allowed somebody to
Okay,
infringe into a
Carl,
setback
you're
when
the
all
one
they
who
had to
wants to
do was
get out.
blast some
Excuse
ledge
me.
to,
You, okay, you
Whatever.
want to get out of here at 7. Let's,
no, I'm just saying, this is my position.
okay,
That this is my,
I respect your
that we
position.
have written rules and we have the interpretation of those rules. And I disagree with this because I know how it has been, and this is not distant thing like Ray Gilmartin. This is even more recent, this is more recently than this. It involves people who are sitting in this room.
All right, all
So,
right, let's.
you know, I don't want hypocrisy, and I don't think, I just don't see the public interest in this. If nobody's coming out none of the abutters are coming out to threaten lawsuits, if nobody, you know, I've had 3, in my lifetime, I've had 6 houses built between me and the water, nobody structures, I got 2 more going in. 2 more going in. I could have, when I sold the land in front of us, we could have gotten an easement to secure my view. I didn't do it. But, and then we're getting into, the view and this and that, which isn't, you know, whatever. I'm just.
See, right now.
I think we should proceed. I think there was no reasonable alternative.
That was the.
So we go to E.
So, regarding the natural environment, the project here is only affecting about 2% of the total lot area. If we move this further away, make it bigger, build a wholly separate building, whatever the other alternatives could be, we're gonna be using more land, more resources, more building materials. We're gonna have a bigger impact on the environment. This is designed to have the least amount of impact on the environment and to resurrect and reuse a building that was, built 100 years ago, rather than just disregard it and maybe tear it down, whatever. So, trying to make it useful again and doing it in a way architecturally that is, good to the, probably not the natural environment, but, is a benefit to the neighborhood and to the neighbors. That they all live in the natural environment. So we're basically trying to minimize the impact on the environment for what we're doing. We would have a right to build a 4-bedroom house on that particular property, and this is a way we're gonna be building for the least impact on the environment.
I'm sorry, did you say you had a right to build a
Well-
4-bedroom house? I couldn't hear what you said. I'm not trying to be
No.
disrespectful.
We have a right, it's a residential zone, and we could build a 6-bedroom house, we could build a 4-bedroom house on that particular lot.
Why
Because,
do you say
Why
that?
do you say that?
well, the lot is large enough to build a house on, as long as they meet all the setback
It's a
requirements.
non-conforming
It's a
lot.
non-conforming, it's 1,000 square feet.
No, it's not 9,000 square feet, it's more like 20,000 square feet.
It,
It's only point
There are 3
2
lots.
acres.
No,
it's point,
these lots, that are part of this thing, this lot, and this lot are all in common ownership. And-
Yeah, but the application,
No, the app-
this is a separate tax lot to the town. It's a whole separate thing. This is not a combined thing. As far as the application is concerned, this is taxed by the town separately.
We submitted the application based on all the lots that are owned there. You could not separate those lots under the current rules because, if I understand correctly, I cannot create another lot out of the 3 lots that we own in common ownership for right now that is a non-conforming lot. Now it's after 1982 or whatever that.
That's fine. I mean,
So we could never separate this lot. Sell it separately or do anything else with separately without these lots attached to it because they're in common ownership and common ownership prior to the development. So they may be treated as separate lots from the tax standpoint. They could be combined and create one lot, but
it would be a non-conforming lot. So,
yeah, but it's still a non-conforming. The one exception of it not being a non-conforming lot is that the ordinance, I believe, says that if it's not the 1.5 acres or whatever is required, but it's more than, actually, it doesn't say, as long as you can meet within the line, as long as you can meet the setback requirements for whatever you're building, you can build on any section of this. I mean, these 2 lots that are combined in one lot, which is 47, I guess, is essentially twice the size of that.
Mhm.
They're still non-conforming, no matter how you slice them, they're all non-conforming lots.
they are, no.
And,
excuse me, would you mind?
no, that,
You wanna come up, Bob? Are you able to?
Bob Ernest, North Road, again, speaking as a former member of the planning board. Just to clarify, I think what we'll find in talking to an attorney is that if you have 3 separate parcels that are owned by the same entity, then they are legally one lot
right,
as of today, not from a tax standpoint, but legally.
right, yeah,
However, they are legal as one lot as of the date that they were all 3 titled in the same name.
right,
Therefore, if that date was after 1975, they have to meet the requirements of 150 feet of frontage and 1.5 acres in order to be built.
right. That's not the case. The lots were in common ownership.
Oh, I'm sorry, wait.
So the lots were in common ownership back into the, I don't know, 1950s or whatever.
If they were the same name as then they were,
I mean, they've changed ownership since then, but they've changed,
If they changed ownership,
they changed ownership.
that changes the,
No.
no, it's still
No.
non-conforming.
If they were all 3 owned by the same entity.
right, and they're all 3 sold, all 3 of them were sold together at one thing.
To the same person. All 3 of them sold from person A to person B.
B, the person C.
I believe that then. they
That
were
just-
all-
It's a non-conforming lot of record.
Yeah.
But you have to talk to an attorney to clear that up.
And wasn't there something when we became our own town, all contiguous lots in common ownership became indivisible,
Correct.
That's
right?
part of the zoning code.
Yeah.
It is, yeah.
Yeah,
When we became our own town. So like Peggy Jones couldn't sell off a parcel from her property.
that's why we could never sell any one of these 3 things to anybody. We can't even create a separate lot because the lot would be non-conforming. So this, we're stuck with this, whether we like it or not. So I'm not sure whether. I guess we were talking about the natural area, but I guess this came up again, but, so you were asking, I made the comment that we could build a 4-bedroom house to meet what we decided our needs were. If we wanted to build a 4-bedroom house, it's a residential zone, we could build on that lot because it's grandfathered, because it was in existence prior to 1972. It does not have to meet the minimum lot size requirement, which I believe is 1.5 acres. And all you have to do is meet the setback requirements and other, building provisions.
So you could in fact build on that combined lot with a building with none of the problem setbacks.
Well, there are some other limits to it because of this, this drainage thing across here.
Yeah, but still,
But you're right, we can build elsewhere in the lot, but if we're gonna end up spending dramatically more money and we're not gonna be renovating the existing building. To do that, so. No matter what, the
I
objective.
guess my problem here is that I guess we're not here to save you money, but to have you comply with the setback requirements.
Okay, I guess it's a matter of seeing what the practical difficulty is. I'm not sure. It's hard to sometimes understand that, but it seemed to me that having to explain the additional is dramatic. I mean, previous applicants said they could, the practical difficulty was they'd have to move the house. Okay, and you basically said, well, we don't have to do that, really it's a smaller project, but, and as I said, we could move the house, the practical difficulty is, and it's gonna cost us a lot of money to do it. We could build a different place, it's gonna cost us a lot more money to do it. This is the most efficient way to reuse that existing property. And it's consistent with the neighborhood. It minimizes the impact on the environment. And so forth, so that's.
Is the existing facility an integral part of the plan? Because earlier you kind of mentioned that this is, you're gonna just kind of use this peripherally, and that the main structure that you're proposing here would be the primary structure.
Well, it's hard to make it that simple because.
And the reason why I'm asking that is, could you have just left that there and do whatever you do, if anything, with the existing building and make the proposed addition one that doesn't require a variance?
Well, yes, you could do that, but you wouldn't end up being able to reuse the existing building in an effective and code compliant manner.
Unless you move, yeah.
Okay, so that's.
So as for the character of that neighborhood, there's a house, it's the Freeman's house. It was the Freeman's house, the one with the big arch. Like on the corner of Ours Point Road and the Cass Road.
Yeah,
How far,
it's called the Barnacle.
okay,
Yeah, it's an older structure, right?
it's an old
It's not
structure.
owned by the Freeman,
Is
it's
that
owned by
the
the
gas?
Gaston. Yes.
It is the Gassens?
Yeah.
Okay, well, maybe Freeman was staying there at some point. But anyway, so how far is that from the road there? As far as the character of this neighborhood?
I doubt if that house is 25 feet from the road. And I know that one of the side setbacks, one of the side lines is like right next to the house.
Right. So
Yeah.
this is, you would characterize this as one of these funky little neighborhoods where the houses are all crowded to the lines, and
Yeah,
this part isn't really gonna change the appearance of the neighborhood.
no, in fact, building a new 4-bedroom structure in the middle of the lot would change the, would not fit in as well with the neighborhood.
Why not?
Because it'd be a much bigger structure that's, modern and,
You make it.
I mean, you can make it look old, I guess.
Yeah, because right now you're saying we're having two separate structures side by side, so you're
Well,
essentially adding another whole
Well, yes,
to this
it's
lot.
overlap,
Why is that?
but I'm also,
Yeah.
we're only adding 470 square feet of land area being used. If I were to build, if we were to build this, a house that was that big in addition and leave that house there, we're gonna have this unused house. Which I think I indicated here could be used like for daytime, but couldn't live in it. And then you build another big house in the middle of the lot, which would be not very compliant with the rest of the neighborhood, which is all houses built 100 years ago as summer cottages. We're trying to make this this is essentially a summer cottage. The decision to make the addition year round, such that if you're going to build structure, you're gonna put the new walls up and so forth. It almost might as well make it, for very little income.
Well, as opposed to moving it into the L line,
Right.
you had it expressed in your application that you could move it up to meet the setback requirement, but it would require what, an extra 35,000 or something
Yeah,
to join the building.
we'd have to figure out a way to build them the two-story tower. And I guess, you know, that is one nature of practical difficulty, is it's gonna cost more to do it now. I realize you're not here necessarily saving money, but,
No,
but
No, yeah, so that's not really practical, that's not really germane to the. We don't have any obligation to maximize your
No.
ability to use the property. So,
true, but my plan is designed to minimize the impact of the environment, use the least amount of resources possible to do it.
but with $35,000 extra, you could accomplish.
you could actually comply with part setback.
In a neighborhood where there are no buildings that are in compliance, like Cookie
It
Reed's,
really doesn't matter.
Cookie Reed's front setback, how much
Doesn't matter.
Well,
15 feet maybe.
Those are all grandfathered.
Well, no,
Right, but if they were suddenly to say, well, look, I have 300 square feet back here that I could still add another building to, would,
they could do that.
I mean, that's a problem. They're increasing the non-conformity of the lot, which is,
I know.
this is increasing it by a large
That's
amount.
right.
So that's the argument. So what Tad is saying is you could move it, you could move this, what you characterized as an uninhabitable or unusable building, and be in compliance with our code, and then build this addition that you want. You could just move it up to meet the setback requirement.
No, you
Again-
can even move the existing building up and attach the proposed building to it as the plan is given to us, or move the addition up and leave the existing building where it is and put that extra little $35,000 more on it to connect the two and comply.
That's what I would feel more comfortable doing with either of those alternatives, because it, and
And then what we would do is we take a place where there's that house, the Barnacle is probably 15 feet from the road on one
right,
side
but
and
that's a
maybe 20 on the other.
non-conforming
Well,
structure of record.
Well,
So
that's right. And we have a whole island populated
Yeah.
in large parts of the areas of the island where
Yeah.
these camps are very close to each other. There is,
why they're called non-conforming lots of
Yeah.
record.
but we are, some of them. I just think that there is that it has been the practice of this board, that if there weren't additional intrusions, we have gone around the rules several times, and we have done it in recent memory just out of convenience for somebody. We most certainly have, out of convenience for somebody, we allow them to put the corner of a building into the setback out of convenience. And it was about saving money. And I just think if none of the abutters have, written a letter, if nobody is against this, if there are other buildings throughout that neighborhood that are like that, this is a common thing in that neighborhood. The Sharps have a brand new structure stuck onto the back of a non-conforming camp. There are other buildings in that neighborhood where people were allowed to do this. That was built in 1992 by Lewis Ross.
Okay, but that's not what we're.
Well, I know,
talking
but what you're saying is that, as a town, one thing you need to understand, as a town of this size, we don't even need to have this ordinance. We have
But
it
we do
because
have it,
we do.
so
That's
therefore
right.
we must abide
We
by it.
do have it. We also have boards that can allow relief from it. And maybe you need to look at the black and white letter, but I would remind you that when I look at the black and white letter about some of these things that are totally clear to me were not clear to me. And when I look at the, not the black and white, when I think of the idea of governance, and it does matter to me about saving people money, it does matter to me about not changing the neighborhood. It does matter to me about that. So I take into all of that account. And we have, and the way our legal system works is we can do that. So that it can evolve over time, and maybe in situations where we don't think it's particularly just, we can offer relief from it. As I said, I believe we should offer relief from this. I believe we have done it before. I have done it with you. For somebody who's sitting in this room right now, when all they had to do, we allowed them. All we had to do was have him blow some, bring out somebody to blast some ledge. And so I don't see this conformity I don't see this self-righteousness about that point.
It's not.
As a town our size, we don't even need to have that code. We don't even need to have that code. We need to have life safety.
The fact.
We do, and we did because we were all busy and we're relieving Cumberland, and we adopted a code that was anti-growth because they were having this spur of all these constructions around their lakes and they couldn't get fire trucks down to put out fires. So, I don't agree. And, I don't believe that if he has an architect, I don't believe that you two have the confidence to argue any better than they do about how this land should be used.
Okay, Charles, I think you're getting.
No, I don't mean that as an insult. I mean, if you know an objective term of competence, it just means he is saying his
Okay.
architect is a professional designer, they have an engineer, and they're saying, we've really worked hard at this and we've invested a lot of money and we've come up with the decision. And you're saying, well, we know better because we adopted Cumberland's code.
Okay, thank you, Charles.
Well, I mean,
I think.
this property was purchased.
No, as far as our determinant of whether we grant a variance, I'm just telling you,
I feel
you
like,
know what I'm talking about when I talk about
Yes,
it was about
no,
saving somebody some
Charles.
money, making out of convenience. It was clearly,
Thank you. We've gone over that. I'm just gonna read really briefly, a little article that was published by the Maine Municipal Association, which,
I don't care.
Charles, you
We
do
live on
not have,
Street Island, Maine.
Charles, you do not have to be rude, and I am going to read it. A paragraph. A request that zoning boards of appeals must deal with fairly regularly, but which normally can't be granted legally, is the landowner's request for a zoning variance. The court in Maine has observed that when a municipality adopts a comprehensive plan outlining the future growth and development of the community and a zoning ordinance to implement that plan, the people have concluded that the restrictions are necessary for the public benefit and the ordinance should be observed. Therefore, in the court's opinion, variances should not be easily or lightly granted, and a variance should be the exception, not the rule. Rather than abiding by the plan outlined in the zoning ordinance, people seeking a zoning ordinance are asking the Board of Appeals to allow them to use their property in a way that is forbidden by the zoning ordinance. This differs from a request for a special exception, which is a request to use a property for a permitted use under certain circumstances. It is said that a variance is designed as an escape hatch from the literal terms of the ordinance, which, if strictly applied, would deny a property owner all beneficial use of his land and thus result in confiscation. Now, what we're doing here is not denying him all use of his property.
Right,
this
and as I
is-
pointed out,
Charles,
radio
excuse
market
me,
was allowed to
excuse me,
increase
Charles,
the
I
existence
don't-
of a McMansion.
Charles, enough. What we traditionally do on this board, when someone is asking for a variance, is ask them if there's any way they could change their plans to comply with that ordinance. And Mr. Howell has said, yes, they could move the structure. It would cost more, but they could do that. So there's your answer, right there.
And it will not have any change of that neighborhood. Everything is non-conforming in that neighborhood.
It
So,
already, Charles, it already exists, so we're not dealing with that. They're built. We're not dealing with that. If one of the other abutters comes up with an idea to build a nuclear power plant there.
that's not what we're
Oh,
talking about.
no,
We're not
but
talking about
it could be-
nuclear power
yeah, we're
plant.
not talking.
And we are
about-
specifically talking about a variance that we gave. And it was entirely about saving somebody convenience and money. And I'm just arguing, that it has been, no matter what is said on the books, that there has been, that there has been a particular way that things were granted by every chair that I ever served under. And so, that's,
Okay.
and, that was that, and I do not see this, I don't see the whole island being turned into a bunch of nuclear power plants because of this, or that all these non-conforming little neighborhoods, the clusters where buildings are put together, that somehow they're gonna be better off. If we, that by, not allowing some, continuing to allow some more non-conformance, that it is going to, change those places. And that's a decision that seems to have been made by many people over time under the boards that I served, under, John Wilson, Peter Rice, any number of people. And as I said, we did take into account, and I hope you weren't offended when I brought up competency. It just has to do with sometimes, like, I'm not competent to build a nuclear power plant. I build light residential things, so I'm not competent. That doesn't mean that that's not a pejorative. I am just more comfortable with the idea that, in this situation, that, they have a reasonable plan. I do know that the drainage issue through there with the town. I've heard about that for years from Mark Dyer. I do understand the topography of the land. I've worked for the Sharps. They have a similar building, that in that neighborhood that is, the same distance of the line. The old building was the same distance to the line, and, so I don't see the overall adherence to this in this situation. I can understand if it was a nuclear power plant, or if it was somebody with a new residential development and they were wanting to do something, so.
Okay, well, thank you for your opinion. But we're a board, we don't have to all have the same opinion, and it's important for you to express your.
No, and if I could better serve the community by not being on the board to bring up, this.
Okay, well, maybe that's an alternative. If you don't feel that you're serving the community properly by being on this board, then perhaps you should not be on this board. I value your opinion. So it would be a shame to lose you, but if you.
I
mean,
just
we
think the
have rules, I know, Okay,
the hypocrisy of having one standard that applies to
Okay,
people who
I
are
think we got
politically
that.
connected and wealthy, and one standard for other people who have, hired architects and done considerable thought and who are attached to that area, have been their whole entire lives. And that we somehow, because we look at this little thing and we have a competency to say what building should be there and how it should be developed.
Charles,
Greater
that's
than
not
them.
the point.
I believe in home rule, and if I just need to leave and then go and then, put my political energy into repealing our zoning,
Okay,
then that's what I'll do. I'm dying on this hill,
okay,
okay?
I understand you're dying on this hill.
So
And
let's
thank
move
you.
on,
Okay,
take your
let's-
votes, let's vote.
Okay. Does anybody have further questions for the applicants?
Comment that, actually, one of the, Charlotte brought up the issue of the Gathering cottage. And I will note that it has, and it's crammed very tightly on its lot. I think it's probably maybe 10 feet from one lot line and less on the other side. They built since this ordinance was in place, somewhere probably 20 years ago, they built on the back of their house an addition that's the exact same distance from the lot line. It's, you know, the same issue of conformity. It's at least as big as the existing original building.
Okay,
So,
thank you, that,
That didn't involve us, and.
well, I know it.
and it's also not a precedent, we can't use that as, because they didn't comply with whatever, I mean, and maybe they did, I don't know, I'm not saying they didn't comply,
I'm
but,
not saying that,
but it can't be used as a precedent for this board to say, those guys didn't do it, so we shouldn't have to do
well,
it
something
either.
they,
Just-
they
and I don't know, I have.
they needed to get a variance. They got it out.
I don't know anything about it, but I think we need to move on, because Charles is now almost late for his,
No, I think as late as I need to be.
oh, wait, oh, okay. So now you can,
There's, which is according to the town zoning map.
so the property is not located in whole or in part within the shoreland areas as prescribed in Title 38.
According to my review of the town zoning map, that's the case.
Yes.
We were just- I agree.
Okay, has anybody, any other comments or questions for the applicants? Okay, so let's close the hearing to public comment. Oh, yes, Teddy, you want to come back up?
You know, what the people are.
Yes. Be careful.
Very open and I was at myself and my mother. And when we built our house, my parents put a big addition on. Huge addition on the back of the house. It's less than 5 feet from the line. And I don't think it's adversely affected anything. Between our house and the license. The line is, I think it's like 5 feet from the back of my parents' garage to the little greenhouse behind us. I just wanna say that, I can't understand the worry about the state laws, when this is gonna add tax money to the town. And you're putting him in a place where he might not build this. And the town would, if Bob Ernest may agree, would welcome more tax money, correct? Thank you very much.
I'm sorry. Thank you. I'm just trying to digest all this, because we have a member of our board of appeals who's saying,
Yeah, now I wish I had,
the heck with all
I had
ordinances.
opened up the
so
meeting, so
why
I
are-
could have had Cheryl.
Postpone the meeting if you want, I suppose. So if we can get her on board, if that would be something you would like to have. But, I'm prepared.
Then
to
we
vote.
could be deadlocked.
How do you know?
Your opinion.
How do I know?
I don't know.
I just don't know.
The public does not want to know.
Question, we're reading a definition of nonconformity, and in there you mentioned something about reducing the distance to the lot line being, as a definition, being more nonconforming, I think. I'd like you to read that again. It's like,
Okay.
we're dealing here with a distance now that's greater away from the line than the most non-conforming point of the building. And you mentioned something in there about the distance and how it's determined to be non-conforming, more non-conforming.
In the definition of conformity, non-conformity.
Yes. That specifically relates to this.
But Ted brought up a situation where his house, they allowed, Cumberland had the same code. and they were interpreting it that as long as they didn't get, cringe closer to the road.
Right.
We've had discussions about, the hotel wanted to add on. We've had discussions where it was, oh, well, they're not getting any closer to this side back or that. So it may have been, it may have been a folk interpretation of, but it seemed to work, and people, and especially in situations where people weren't opposed to it. I just wondered what the public good in it is.
From my perspective, I've been on the board for the period of time that I have, and I don't recognize any of these apparent situations where variances were given that allow some of the structures that are being mentioned. My purpose is, when I joined the
Excuse
board.
me, Tad, are you saying you don't know what I'm talking about?
Just let me talk, for God's sake.
Well, you just remember, you are forcing me to then announce it in public.
Excuse
I'm not making it up. You are implying that I am saying something that's not truthful.
No,
You
he's not.
do say that, and you don't withdraw what you said. I will have to say exactly what I'm talking about so that you're not smearing my reputation.
Charles, he's not saying anything about you.
Do you want me to name names?
Charles.
I'll name names.
Charles,
Name names?
Mika,
Hi, Victoria Wood, Town Administrator. I just want to remind the board that you are representing the town and
I am.
respectful and kindness would be appreciated during these meetings. And if the board doesn't agree on the ordinances.
And that's right, and that's why I shouldn't be on this board. So I'm out
I
of
think
here.
you should bring them to the board to be voted on and change.
You are forcing me to say it. Okay? Bob Ernest, we gave him a variance so he could intrude into the setback. So he didn't have to do some additional excavation
Can you-
or to do some.
Charles,
Yeah,
can
yeah,
you please
leave me
sit
alone.
down?
Fuck you. Just lost.
Another great board meeting. Well, we no longer have a quorum, so we will have to, I apologize. We are having a few little bumps here. I apologize profusely on behalf of the board. We are going to have to continue your hearing,
At a time of the insurance or?
yeah, we can't even vote now on whether to, use
Yes.
the new Zoom with Cheryl's participation.
She's not in attendance, but yes, you're right.
However, we can get a member from another board and if we can get a board member from another zoning board of appeals from another town to come over, they can sit in our board according to the Maine Municipal Association. Not at this moment, obviously, but if we don't have enough members, that is one alternative. We were told by the Maine Municipal Association. Of course, I don't think they understood that someone would have to take a ferry out and back, but they said, oh yeah, you did have someone else from a neighboring town come. So I apologize.
Okay.
I'm very sorry. We are going to have to.
Yeah.
Bob. Come on up.
Bob Ernest, and I'm speaking now as a member of the select board. I believe you also have the option of having the entire meeting via Zoom. So I think if we follow the rules that the select board follows, we've avoided hybrid meetings. We've allowed people to observe but not participate via Zoom unless the entire meeting is Zoom. And therefore, you could have a meeting via Zoom in which everybody was attending only via Zoom. Is that sound right to you, Vika?
There is, nothing that says that boards cannot conduct meetings entirely through Zoom. So that policy is specific to the select board.
Mhm.
But I think Bob is absolutely right. We do have a number of town boards that are not select board, boards, and occasionally a select board that do all Zoom. So hybrid in person is not. So-
And the other point, I would encourage you to seek legal counsel, given the situation here relative to how to best hold the meeting. Vika can help with that.
Yeah,
Yeah, the one disadvantage of a Zoom is that when people bring in these nice exhibits, or when they come over to the table and say, look, here's the diagram, we can show it to you, that's, but otherwise.
I would just like to comment briefly too. You asked, when the next meeting would be. My suggestion to this board would be to kind of put things on hold, seek legal counsel to get guidance on how to proceed from what just happened and how to best assist the board and the applicants at hand, and then come back with whatever the next step would be. So at this point, probably not have an answer of when the next meeting will be until the board seeks a little bit more guidance as far as what to do and how to move forward.
Okay.
Thank you. Yeah, thanks a lot.
Yeah, thanks. Yeah, and thank you for appearing.
Well, thank you for listening. And I'm sorry to come to some. I don't